Et je cède maintenant la parole à Roman Kwiecień, qui nous donnera son exposé, je crois, en anglais. Is there a final arbiter of constitutionality in the European Union? The supremacy, primacy issue revisited.
Merci beaucoup. Madame et Messieurs, je suis vraiment content de la participation au colloque dans ce lieu magnifique. Merci de m'avoir invité. Avant tout, merci pour l'organisation de notre conférence. Malheureusement, je ne parle pas français bien. C'est pourquoi je vais parler anglais. Je vous prie de m'excuser. Is the final arbiter of the constitutionality of law in the European Union? This is the topic of my presentation. I am address the problem which is firstly interesting and vital for scholarship, secondly important in practice, and thirdly still unresolved because of its ambiguity. At the outset, let me remind one judgment of the United States Supreme Court. The judgment was given in the Marbury versus Madison case of 1803. The judgment is seen as a leading milestone on the road to what is called constitutionalism. Notwithstanding the signing of the United States Constitution on judicial review of legislation enacted by the US Congress, Chief Justice Marshall, finding a conflict between a statute enacted by the Congress and the Constitution, considered it the essence of judicial duty to follow the Constitution. This approach supports what is sometimes labeled as sovereignty of law. As far as the European Union is concerned, a question arises. Is there a judicial body which is ultimately entitled to adjudicate the conflicts between European Union law and national law? The origin of the problem is connected with what may be called as frictional phenomena. That is a clear tendency of the national constitutional courts to defend their power within the national legal orders and not to recognize the competence of the European Court of Justice in this respect. As such, the problem nolens volens concerns the old controversy, primacy or supremacy of European Union law. Both issues are interconnected. To be more correct, the problem of the final arbiter of constitutionality of law in the European Union can be put in the following way. Is it the National Constitutional Court or the European Court of Justice that ultimately determines the relationship between national law, including, of course, constitutional rules, and European Union law? My answer is rather pessimistic. I claim that there is no final arbiter of constitutionality within the European legal space. It follows that both the national courts and the European Court of Justice decide constitutional problems with accordance with their own logic, own judicial logic, internal to each judicial system. It also follows that there is no common judicial logic within the European legal space. Let me present the justification for that view. European Union law is often presented as being unique and autonomous because it is endowed with direct effect and primacy over national law. The primacy principle is even seen as the embodiment of actual transfer of constitutional power to Europe. Is it really true? I object to treating European Union law as entirely unique and autonomous, that is independent on the one hand from national law, and on the other hand as a different from international law. The Luxembourg Court, the European Court of Justice, takes different stance. According to the Luxembourg Court, the European treaties established own legal order which has special and original nature. Those phrases, own legal order, special and original nature, come from one of the most famous judgments of the ECJ, Costa case of 1864. According to the European Court of Justice, the European treaties have aspired to be real constitutional acts. The title of the Traité établissant une constitution pour l'Europe, Treaty Establishing a Constitution for Europe of 2004, this treaty proves it clearly. But a question arises whether the European treaties are different from treaties as sources of international law. The views of the national constitutional courts are important in this respect. For instance, Conseil constitutionnel, in its decision of 2004 concerning the mentioned constitutional treaty, concluded that it was just an international treaty, and its title was of no constitutional significance. I share this view. Why? Because it seems to me that European law has not ceased to be international law. Has not ceased to be international law. It seems to me that it is only the judicial control held by the European Court of Justice that makes a unique feature of European Union law in international legal space. In most other international judicial or quasi-judicial systems, there is no direct link between international court and national courts, making it much more difficult to coordinate legal interpretation across boundaries. The other judicial or quasi-judicial systems are simply not able to create serious domestic political costs for ignoring an international court ruling. In the European Union, there are really serious domestic political costs for the ignoring of the European Court of Justice ruling. Maybe there is another exception. The system based on the European Convention for Human Rights and Fundamental Freedoms, which is built on the judiciary of the European Court of Human Rights. I used so far the term primacy, as now it is often used the term supremacy. Both terms are often used interchangeably, at least in the English language literature. The term supremacy, more than primacy, implies the hierarchy of norms as well as the validity of norms. As such, it has real constitutional consequences. The European Court of Justice itself has not used the term supremacy, unlike the national constitutional courts. This term, supremacy, appeared only once in the judgments of the European Court of Justice, That was a case Wilhelm of 1869. In that case, the European Court of Justice spoke of supremacy of community law. In the French language version of the judgment, it sounds le caractère prééminent du droit communautaire. Le caractère prééminent du droit communautaire. The view of the European Court of Justice on the issue primacy, supremacy is pragmatic one, namely, this is effectiveness and uniform application of European law that are the reasons for primacy, while the primacy doctrine itself justifies the existence of European law as a legal order. The European Court of Justice requires only due to the effectiveness of European law non-application of the inconsistent national rules, including, of course, constitutional rules, but not their invalidity. It also requires remove by national agencies national legislation that is contrary to European Union law. But the Luxembourg Court has never touched the validity of national law and has never pointed to any kind of hierarchy of norms between European Union law and national law. That is, however, done by the national constitutional courts when the relationship between national law and European law is taken into account by them. The national court often use the term supremacy, whereas the European Court of Justice has used neither superior legal order, inferior legal order, nor the term supremacy, as I said. The judgment of the European Court of Justice support what is sometimes called European monism or constitutional pluralism. In such an approach to the relationship between European Union law and national law, the hierarchy of sources of law is challenged, and instead of the term hierarchy is even used the term heterarchy. The national and constitutional courts, however, have rejected the European monism presented by the European Court of Justice and rather support the dualistic prospect of implementation of European Union law in the domestic sphere. They emphasize their own role as guardians of the basic national law against constitutionally unfounded actions and legal acts of international agencies. They, that is, the national constitutional courts, recognize themselves as final arbiters of constitutionality within the state. Looking at the decision of the national courts, I mean especially the German Constitutional Court, the Bundesverfassungsgericht, one can say that the national constitutional courts even aspire to control the activities of the European Union institutions under the conferral principle. The Polish Constitutional Court, in its judgment on the accession treaty of 2005, clearly claimed, I quote, "Should the adoption of European Union provisions infringe the framework of conferred powers, the primacy of European Union law fails to apply with respect to such provisions." What does follow that from? It follows that the national constitutional and supreme courts perceive European Union law as rooted in national constitutions and combine foundations for their primacy and direct effect in domestic spheres with these constitutions. One could argue that attributing state powers to international institutions, to European institutions, is one thing, and deciding upon the domestic effects of rules adopted by such institutions is different thing. In other words, an acceptance by the national constitutional courts the role allocated to them by the European Court of Justice is selective and based in fact on the national constitutional terms and conditions. That is why the effectiveness of European Union norms is shaped by the pre-existing structure of the national legal order. It follows that as long as the member states retain the position of subjects vested with competence, remember what said the Bundesverfassungsgericht, the member states that are masters of treaties. Once again, as long as the member states retain the position of subject vested with competence, constitutionally protected values will be exempt from the operation of the primacy principle of European Union law, let alone supremacy. On the other hand, however, the international legal duty to observe European Union law is indisputable. I want it to be strongly emphasized. This is a simple issue of legal obligation, thus it has nothing to do with sovereignty of the member states. This is a simple issue of legal obligation, observance the European law. We must remember about that. But this obligation, this international legal obligation, for the national courts, according to constitutional courts, should be constitutionally authorized. According to the national constitutional courts, all state agencies are obliged to apply European Union law, because failure to observe it continues not only infringement of international law, European law, but first of all, it constitutes a constitutional tort. A constitutional tort. What was said inclines to describe the unique body of law created by the European treaties as a constitutional order of states. Those are the member states that still remain the principal lawmakers within European integration process. The member states confer powers on the European Union and not the other way around. The values that make up the legal status of the member states cannot be interfered by European Union law. Consequently, legal acts of the European Union which are contrary to the conferral principle, this principle is given in Article 4 and 5 of the Treaty on the European Union. So all European legal acts contrary to the conferral principle would be qualified as ultra-vires acts. As such, they cannot be protected by the primacy clause. The argument from legal certainty is important in this context. That certainty must first of all exist from the perspective of the transfer of the powers in question, that is, from the member states, and not from its transferee, that is, the institutions of the European Union. And let me give some final remarks. The national constitutional and Supreme Courts do not entirely share the interpretation of the primacy principle given by the International Court of Justice, because according to them, this interpretation brings an explanation not only European law, but also problems covered by national constitutional law. If a dispute arises between the European Union and one or more of its member states as to the existence of competence of the Union, then the European Union and national legal systems will each decide the matter in accordance with the logic internal to each judicial system. Each system has its has its own hierarchy of norms, and although both systems have influenced each other and partially overlap, each ultimately retains its own rule of recognition in Herbert Hart's meaning. If they come into conflict, then there will be conflict in which there can be no arbiter, there can be no praetor. And if the conflict between national legal order, in particular its constitutional rules, and the European Union legal order cannot be resolved, the member states can do what was pointed out by the Polish Constitutional Court in its judgment on the European arrest warrant of 2004, that is, leaving the Union. Withdrawal from the Union would definitely finish the final arbiter dispute. The conflict cannot be resolved, just 1 minute. The conflict cannot be resolved until one of the two legal systems gives way and adopts the rule of recognition of the other as its own. And it will be resolved in favor of the European Union only if the European Union develops into a true federal state with a unified legal system. Then the European Court of Justice would obtain a position analogous to that of the US Supreme Court, and national constitutional courts would be relegated to a position of the state Supreme Courts in the United States. But the European Union is not a state, and the European integration process does not act beyond the states. That is why there is no final arbiter within the European legal space. C'est tout, Madame et Messieurs. Merci beaucoup pour votre attention.